Docket.
A brief written summary of a document.
Docket.
A formal abridged record of the proceedings in a legal action, a register of such records.
Docket.
A list of legal causes to be tried, also the caseload of a court or judge.
Docket.
A calendar of business matters to be acted on, agenda.
Docket.
An identifying statement about a document placed on its outer surface or cover. To place on the docket for legal action. To make a brief abstract of something such as a legal matter and inscribe it in a list. To inscribe something such as a document with an identifying statement. I done told y'all they codify everything in a codified society with a governance structure that's ruled by code. So let's take a look at what's being codified and who's fighting over the code today. All right, so as you can see here, law tech tools on Cartoon Brew, that tech giants say their users or that the users of their software should be held responsible for AI copyright infringement. AI developers say it's not their fault that their machine learning programs produce copyrighted material, even though they are the ones who train their systems on copyrighted materials. Instead, they want users to shoulder the legal responsibility of material generated by their systems. The U.S. Copyright Office is mulling over new regulations regarding generative AI, and in August published a request for comments on artificial intelligence and copyright. Responses to the request are public and can be found here. Now, I want to pause right here. How many times have I told you guys to check the code of federal regulations and check for public comments in the dockets on rulemaking and non-rulemaking even, right? Find out what is being argued and what is being stated about you and your freedoms. Did you go to put a comment? Did you go and respond? Let's see. As you can see, here is regulations.gov. Your voice, right under there, your voice in federal decision making. How are you infusing your voice into the code? Non-rule making docket. So it was created by the U.S. Copyright Office. Did you put your comment in? How is the U.S. Copyright Office supposed to understand your view on this topic or this issue? Did you put your comment or response in? Okay, did you let your voice be inserted in the federal decision making of the code? Even though this is a non-rule making docket, it still holds a lot of weight for you to put your comment in. Let's see who put their comments in. So if you go down, you see docket details. You can browse the documents. Let's see what's in here. Artificial intelligence and copyright extension, artificial intelligence and copyright, artificial intelligence and copyright. So these are new. And the agency is right here, the U.S. Copyright Office, September 21st, gives you an ID. You see all of that, August 30th, 2023. And you can still comment right here. If you click comment, you see comment, all by December 6th. So you still have time to let your voice be heard in federal decision making. Now let's go back. You can even browse the comments. Let's see. This person did a public submission. Now you know that these are public comments about the public's business at the .gov website right here, regulations.gov. All right, let's see what the comments say. We got a comment right here. Oh, it is my opinion that using copyrighted works to train AI models is legitimate and fair use of these works. Okay, that's one person's comment, and you can go down and view more comments. This comment is given an ID and a tracking number because, this is a codified system. And of course, it's going to ask for a name. It's not going to give any personally identifiable information on the public website of the public comment and response about the copyright and AI. Okay, so then you can go down here, press again, browse all comments. Oh, you can even remain anonymous. You can remain anonymous and you will still have an ID attached to it and a tracking number because all of this is codified, right? So all of it is assigned to the code. Okay, you get it? AI art models can create a facsimile of an artist's work, effectively stealing their labor, from them, and simply by adding the artist's name as a tag. The reason this is possible is because the AI art model is usually trained using the artist's work. Additionally, AI art and AI writing is usually of much lower quality than artwork and writing created by a human. All you have to do is look at the AI model, try to draw hands or noodles or anything with fiddly details. Okay? Now, I also saw a comment that was about people getting paid, right? But these comments are being uploaded essentially by the moment, because I was looking at Robert Lambert's comment as the last comment, and then I saw more comments coming and being posted. So here you have right here, neither individuals nor businesses should not be allowed to copyright AI generated content. And using someone else's copyrighted content in their AI training data should be considered intellectual property theft. As an artist, I think it's very important that we protect the rights of creators rather than opening the door to rampant misuse of other people's creations without compensation. You see, that's assigned a common ID and a tracking number, and it was received August 30th. And I'm saying to you, regulations.gov, your voice in federal decision making, you can call and complain to your auntie and your cousin and your uncle, Paw and Nana, but did you tell the federal decision makers? Did you talk to the U.S. Copyright Office? Okay, I want to know. Because in a codified system, with a governance structure that is codified, U.S. Constitution, 3 branches of government, a bicameral legislature, also called Congress, executive, judicial, and legislative branches that operate off of the U.S. Code of Federal Regulations, or you can call it the U.S. Code. USC is the way you see it abbreviated. CFR, Code of Federal Regulations, is another way you see it abbreviated. Did you insert your voice into the code? Codified, codex, codification, by manuscript, by hand. People have to be able to put into the code their voice. Taught about this before, y'all need to be paying attention. All right, so you can even complain to me. And when people complain to me about whatever it is, I go and insert something codified. Okay, so here we have right here, among the replies, companies including Google, DALL-E, developer OpenAI, and Microsoft wrote in, arguing that only the unlicensed production of copyrighted materials violates existing protections. According to them, AI software is just like audio or video recording devices, photocopiers, or cameras, all of which can be used to infringe on copyrights. Manufacturers of those products aren't held to account when that happens. So why should AI companies be held accountable? Or so the thinking goes. And you can look at the documents on the regulations.gov site that I just showed you and read exactly what is being stated in these replies from the AI tech giants, okay? And Microsoft, which has a multi-billion-dollar partnership with OpenAI, wrote, users must take responsibility for using the tools responsibly and as designed. To address the concerns of right holders, AI developers have taken measures to mitigate the risk of AI tools being misused for copyright infringement. Microsoft incorporates many such measures and safeguards to mitigate potential harmful uses across our AI tools. These measures include meta prompts and classifiers, controls that add additional instructions to a user prompt to limit harmful or infringing outputs. It should be noted that safeguards that Microsoft supposedly has in place have done little to prevent mass trademark and copyright infringement. In fact, the Walt Disney Company recently asked tech giant to prevent users from infringing on its trademarks. Let's look at that. Okay, so they have a law tech report about the way that Disney asked Microsoft to prevent AI users from infringing on its trademarks. And this was posted on 11/18/2023, right? And it starts out with tributes and parodies of Pixar-style characters generated by Microsoft's Bing AI imagining tool have drawn the attention of the Walt Disney Company's legal counsel. So you can definitely go and check out what's being said here from Disney, and then you can look at what the Financial Times reported, right? But none of this matters if you didn't respond, and we still have time by December 6th, to the federal decision makers at the U.S. Copyright Office. Because you don't have big tech lawyers and you don't have Walt Disney lawyers. So how do you get your voice inserted into the federal decision making? And you don't think that the public's voice matters when the U.S. Copyright Office has to look at all those comments? And it has to go into the federal psyche, let's just call it that, right? Consciousness about what the public is thinking and saying. And how many are in support and how many are like, nah, this is not okay, right? Think about that. Insert your voice into the code, codify it through commenting. All right, and so then Google, meanwhile, argued the possibility that a generative AI system can, through prompt engineering, be made to replicate content from its training data does raise questions around the proper boundary between direct and secondary infringement. When an AI system is prompted by a user to produce an infringing output, any resulting liability should attach to the user as the party whose volitional conduct proximately caused the infringement. So there, you see that they're saying that you are the one that utilized the AI. You're the one that prompted the system to create something. The responsibility is based on what you did as far as prompting the system, and the system is creating based on your prompts. So you, the user who put the prompt in, are responsible for the copyright infringement. Okay, a rule that would hold AI developers directly and strictly liable for any infringing outputs users create would impose crushing liabilities on AI developers, even if they had undertaken reasonable measures to prevent infringing activity by users. Had that standard applied in the past, we would not have legal access to photocopiers, personal audio and video recording devices, or personal computers, all of which are capable of being used for infringement as well as for substantial beneficial purposes. So what they're liking AI's, generative capabilities to, based on the user, you who put in the prompt, is to a copy machine, a printer, a video camera. It's like a camera, right? But what they're also saying is that hey, this is all a tool. AI is all a tool. You, the user, put in a prompt. And when you put the prompt in, you're the one guiding this tool to do what it says, like using a calculator, right? And so whatever the outcome of that prompt is, the big tech is not responsible for any of that. You, the person, is. And even though they created this tool, it's just a tool that people guide. So at the end of the day, legally, the user is responsible for the copyright infringement, is their argument. All right. And so OpenAI wrote, in evaluating claims of infringement relating to outputs, the analysis starts with the user. After all, there is no output without a prompt from a user, and the nature of the output is directly influenced by what was asked, right? It's depending on how the user sees the tool and then goes out and shares that information. So if I, as a user, am engaging with AI and I put in a prompt and it brings back things that could be copyright infringements, right? I'm supposed to be able to know that that's a copyright infringement and not share that information as if it's my own. Because after all, I only prompted the tool to do something. I didn't officially create it, the tool did. And so whatever the outcome is based on what your responsibility to do with that material is, what you put in. You don't take that AI prompted information and just post it as if it's your own. It's your responsibility to check, is what they're saying. And look, I feel like if you're a creator and if you're a writer, if you're a journalist, whatever that may be, you should be able to create information on your own. But if someone else takes that and replicates it and doesn't give you credit, there is a problem there, right? So there's a lot of gray areas in this. And you need to make sure that you codify your response, not by chatting with me in my chat box, but going to regulations.gov and taking your voice to the US Copyright Office, right, in a codified system. So let's keep going. It's worth pointing out that all of the above companies have used copyrighted and trademarked material without permission to train their software. And OpenAI is currently being sued by over a dozen major authors who accuse the company of infringing on its copyrights. So basically, OpenAI infringed on writers by taking their material without permission, is what this is a claim that's being made, right? Prominent ones at that. And then they filed a suit with the Authors Guild accusing the AI company of infringing on their authors' copyrights, claiming it used their books to train its ChatGPT chatbot. And you guys are prompting OpenAI chatbot and stuff like that to do something based on material that the companies are being accused of is stolen. Okay. So what is that like? Are you a thief now too? If you use their stuff and they're claiming that it's stolen, you need to think about that. All right, so let's go on. And to further muddy the waters, despite these companies telling the US government that users should be liable for the output of their systems, many of them, including Google, OpenAI, Microsoft, and Amazon, are offering to cover their clients' legal costs in copyright infringement suits. Did you get a copyright infringement? Were you copyright violated? Like saying on your platform, if you utilized some of their materials, did YouTube say you violated the copyright rules? Okay, and if so, did big tech cover your legal costs if you got into any situations? I know students that are using Grammarly, and when they turn in their documents or their research papers from just Grammarly, watch this, they allowed Grammarly to change their sentences or fix their words, and then that is detected as a plagiarism. Okay, who's going to help those students that got kicked out of school, colleges, for plagiarism? Are they going to send the legal counsels and pay the cost then? I'm talking about the way that these things are generated from stolen information that you didn't know that people were accusing these companies of stealing. And then you go and put in a prompt, and then you get some of that stolen information bit by bit. That's what's being claimed by the authors. Okay. And that's what it looks like it's being claimed by Disney, right? Because they used these items without permission and to train AI. So ultimately, the companies argue that current copyright law is on their side and that there is no need for the Copyright Office to change that. At least not right now. Well, not if the public informs the Copyright Office that this is not okay, right? Or that, hey, we love it. And we don't care if the Authors Guild or Disney or anybody feels like it's wrong. We like what you guys are producing and helping us as users be able to put in prompts and, create a, document or a picture or whatever that is. And, you go over there and you tell the US Copyright Office, right? And so we'll see how the public is able to get into the psyche of the US Copyright Office through their comments and responses about what is happening in this non-rulemaking docket, okay? And so they say that if the office cracks down on developers and changes any copyright law, it could hamstring the nascent technology. In its letter, OpenAI said it urges the Copyright Office to proceed cautiously in calling for new legislative solutions that might prove, in hindsight, to be premature or misguided as the technology rapidly evolves. Perhaps surprisingly, the major film studios are on the side of big tech here, though they are coming at it from a different angle. In its submission to the Copyright Office, the Motion Picture Association, MPA, drew a distinction between generative AI and the use of artificial intelligence in the film industry, in which AI is a tool that supports but does not replace the human creation of its members' work. The MPA also argued against updating current legislation. Boy, they don't want this legislation updated. They want for AI to be able to fully roll out, and let's see if it fixes itself, even though they trained it with materials that are being claimed stolen. It's like colonization just don't stop. Anyway, MPA's members have a uniquely balanced perspective regarding the interplay between AI and copyright. The members' copyrighted content is enormously popular and valuable. Strong copyright protection is the backbone of their industry. At the same time, MPA's members have a strong interest in developing creator-driven tools, including AI technologies, to support the creation of world-class content. AI, like other tools, support and enhances creativity and draws audiences into the stories and experiences that are the hallmark of the entertainment industry. Can't the human mind do this? Can human ingenuity and, intellect, like we're sitting here arguing about what AI can and shouldn't do and whether it's a tool and how it creates and all of this other stuff. What about your brain? If you can effectively argue and respond to these things, then you should be able to think of something else. Like that's time we could have spent creating something on our own, right? And so, just think about that. Like if you can critique and evaluate and do all of this stuff about what AI is generating and whether or not it is, actually creative or if it's stolen or whatever you want to call it. And, I got to have a whole bunch of fancy words. Don't you think you just could have took that time and thought of it on your own? Just think for yourself, right? Yeah, I get it. It's a tool. If I have an algebra problem, I'm going to use a Texas Instrument calculator or whatever I can to help me figure out and solve for that tool, right? It's part of the processes. But then when you're saying, no, the actual thing is that you're using stolen property. I mean, I find an ethical dilemma there, right? Because of the foundation. If the foundation be corrupt, then what can we do? That's going to be right from there, right? And so you should ask the people permission to use their stuff. It's not okay to steal stuff. It's not okay to use things and then continue to perpetuate that out. If we, as the users, are prompting and asking for stolen information and stolen material, I find an ethical and moral dilemma to that. MPA's overarching view, based on the current state, is that while AI technologies raise a host of novel questions, those questions implicate well-established copyright law doctrines and principles. At present, there is no reason to conclude that these existing doctrines and principles will be inadequate to provide courts and the Copyright Office with the tools they need to answer AI-related questions as and when they arise. Even though the MPA writes that existing copyright laws are sufficient, it offered strong objections to the idea that AI companies should be able to freely train their systems on their material. In its letter, the MPA wrote, MPA currently believes that existing copyright law should be up to the task of handling these questions. A copyright owner who establishes infringement should be able to avail itself to the existing available remedies in Section 502-505, look that section up, including monetary damages and injunctive relief. At this time, there is no reason to believe that the copyright owners and companies engaged in training generative AI models and systems cannot enter into voluntary licensing agreements such that government intervention might be necessary. And so why is government intervention necessary if there was the ability and there was enough protections, right, through Section 502 and 505 of existing copyright law? Then why is there government intervention and why is this issue being raised? Right? I showed you other examples about it, but definitely want you to let me know when you go over, not look at these comments, right? You can look at these comments, that's fine. You can also add your comment in to Cartoon Brew, that's fine. But what I need you to do, if you really want to be involved in this situation and have your voice heard in the federal decision-making process of the non-rule-making docket on artificial intelligence and copyright created by the U.S. Copyright Office, is going over here to this site and open up the docket details, go right here on the browse documents and put your comment in by December 6th. By December 6th, you should have your comment in. Let me know what you commented if you want to. It doesn't matter anyway, because even if you comment here about what you commented there or you don't, it's going to be public. So make sure you make your voice count. Talk to you later.